The exposure draft is being released generally today, and there will be a period of community consultation of 1 month in which we will be inviting, and the details are on the press release, we'll be inviting members of the community to comment and give us feedback on the exposure draft. But let me speak quickly to it. Before the last election, Mr Abbott and I promised to repeal Section 18C of the Racial Discrimination Act in its current form. The reason we did that is because, as illustrated by the decision in the Bolt case, although not only by that decision, the current language of Section 18C is unreasonably restrictive on freedom of speech and, in particular, on freedom of public discussion. But there is a second reason why it is the view of the government that Section 18C and related sections should be removed from the Act and replaced, and that is because they do not effectively or competently address the very vice they are meant to address, and that is racial vilification. It is one of the misconceptions in this debate that the Racial Discrimination Act prohibits racial vilification. It does not. The term is not used in the Act, and Section 18C does not prohibit the incitement to racial hatred, which is the most commonly accepted meaning of the term racial vilification. I have said all along, and Mr Abbott has said all along, that a properly worded section can achieve both objectives of protecting legitimate freedom of speech and freedom of public discussion about matters of race, while at the same time containing protections against racial vilification and other unacceptable racist conduct. This proposed amendment does both. These are the strongest protections against racism that have ever appeared in any Commonwealth Act. But they are more effective because they don't adopt the method that the pre-existing Section 18C adopted of effectively political censorship. They target the particular mischief concerned, that is racial vilification, and prohibit it. Now, let me take you quickly through the document which is attachment A to the press release, and which, as I say, is an exposure draft for community consultation and represents the government's thinking in relation to this matter, but about which we are very open to other suggestions. First of all, the words offend, insult and humiliate are gone. You can't have a public discussion of an issue, particularly an issue about which people feel very strongly, I might say, without offending or insulting a person who has a strong contrary view. In Parliament, the principal debating chamber of the nation, we offend and I dare say we insult each other every day. That is part of the robustness of discussion of public issues. The inclusion in Section 18C in 1995 of those words, against which the then coalition in opposition warned at the time, has had a dangerous effect on stifling and, in fact, censoring public discussion of important social issues, as we saw in the Bolt case, the most infamous example. The word humiliate is also gone because it's not possible to have a public discussion about a difficult issue about which different people feel strongly without running the risk that somebody who takes a strong contrary point of view might feel that their view is being mocked. Mockery is a legitimate part of public discussion and part of public commentary. You, ladies and gentlemen of the press, mock politicians every day of the week, and so you should. It's part of the robustness of democratic exchange. So humiliate is gone as well. Those three words, offend, insult, humiliate, describe what has sometimes been called hurt feelings. It is not, in the government's view, the role of the state to ban conduct merely because it might hurt the feelings of others. Our democracy should be robust enough for that. Intimidate, however, stays, because intimidate is not about hurting people's feelings. To intimidate a person is to cause them to be fearful. That's an entirely different state of mind. It's an entirely different concept. People are right to go about their daily lives free of fear, including fear born of intimidation because of their race or colour or national or ethnic origin. Intimidation is not an aspect of legitimate public discussion, no matter how robust that discussion is. So intimidation, in our view, should stay. Vilification, as I said in my opening remarks, is added to the section. To vilify someone is to incite hatred of them. The absence of a prohibition against vilification has been a gaping hole in Section 18C in its current form. So the measure that the government announces today, at least in an exposure draft form, contains stronger protections against people on the basis of for protection from wrongful conduct on the basis of their race or colour or ethnic origin than the previous Section 18C. Nor does the prohibition of racial vilification constrain public discussion, because to incite hatred is no part of the exchange of ideas. To incite hatred is not an aspect of freedom of speech or intellectual freedom. In subsection 2 of the exposure draft, those two terms are defined. They apply to groups as well as to individuals. They apply to damage to property as well as to the person. Subsection 3 restates the community standards test. That was always understood to be the law, the meaning of Section 18C, before the Bolt case. But in that case, the judge took a very narrow view of how reasonableness was to be decided. He thought that the relevant group was a representative member of the so-called victim group rather than a reasonable member of the Australian community. The community standards test, in other words, didn't survive the Bolt case. We believe that the test of reasonableness in this area of the law, as in all others, ought to be community standards. And I might say that in the many discussions I had with various members of leaders of ethnic community groups, they themselves were of the view that the community standard test should be reinstated. Subsection 4 effectively replaces the existing Section 18D, and it makes the protections for public discussion broader. Section 18D, in its current form, does not specifically protect political, social or cultural matters or discussion of political, social, cultural or religious matters. They should be protected, and under this proposal they are. The exposure draft which the government releases today achieves the two objectives which the Labor Party claimed could not be achieved, of protecting Australians from racist conduct while protecting Australians against invasion of their freedom of speech and their right to speak freely about difficult social questions. It should also be remembered that Section 80.2 capital A of the Commonwealth Criminal Code exists to protect people from the incitement to racially motivated violence. And of course there is the ordinary law of defamation which protects reputation. So those various parts of the law taken together protect people from the incitement of hatred. They protect people from the incitement or causing of fear. They protect people from the incitement of violence, and they protect their reputations. That is where the government believes the law should be. That is where the government believes the line is best drawn between proper protections against identifiable harm and freedom of public discussion and freedom of speech.